Straight ahead on Law and Crime Daily. Opening statements in the so-called Daytona Beach serial killer trial.
Mr. Robert Hayes is guilty beyond a reasonable doubt of killing, not once, not twice, but 3 times.
Plus, 8 years after a deadly shooting at a Florida movie theater, opening statements are set to be presented. And the death of Amir Locke.
Our son died by the hands of Minneapolis police, a trigger-happy Minneapolis police officer.
How Locke's family is seeking justice. But first,
State of Wisconsin versus Darrell Brooks.
the deadly Waukesha Holiday Parade. What plea accused Darrell Brooks enters. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terry Austin. The man accused of killing 6 people and injuring dozens more in the Waukesha Holiday Parade pleads not guilty to more than 70 charges. Accused Darrell Brooks Jr. appeared in Waukesha County Court on Friday for his arraignment. Last November, prosecutors say 39-year-old Brooks drove his vehicle through a crowded holiday parade, killing 6 people and injuring dozens more. He now faces 77 total charges, including 6 counts of homicide and multiple counts of reckless endangerment. In a brief court appearance on Friday, the court commissioner announced a new judge will be appointed to the case. Brooks' defense team also entered a plea on behalf of their client.
Good morning, Mr. Brooks. We are here on your arraignment date. Uploaded into the file yesterday, I believe it was a motion for substitution of judge. That is timely filed, and already the matter has been reassigned to Judge Doro. And so let me turn to Attorney Perry. Attorney Perry, will Mr. Brooks acknowledge that he has received a copy of the information, and will he waive its reading?
Yes, we've received a copy of the information. We'd waive formal reading, and we can enter pleas of not guilty this morning.
Brooks' attorneys filed for a change of venue motion due to national media attention the case has received. Brooks is set to appear in court next month. Joining us today is criminal defense attorney Matthew Mangino and Terry Austin. Matthew, as we learn more and more about Brooks Jr.'s criminal history, how does that affect the investigation into why his bail was so low?
Well, Brian, it's really interesting. As I understand it, he had a 50-page rap sheet, which means he had a series of charges and convictions over an extended period of time. When you consider bail, you look at 2 different things. One is this person likely to evade further hearings and leave the jurisdiction, not be available for trial. And number 2, is he a safety risk? Is there a risk that he could offend while he's on bail? And that's what happened here. So it's really difficult to imagine a scenario where the district attorney or the court, having been aware of a 50-page rap sheet, would set his bail at $1,000. So it's going to be interesting to see where this investigation goes.
Yeah, that's definitely a head scratcher. I'm not a big proponent of pretrial incarceration, but this seems to be a situation that seemed like someone overlooked something. Terry, Brooks filed a motion for change of venue, but this case has had national attention. So will he be successful?
Well, I doubt he will be successful, Brian. Change of venue is always made when the defendant or his attorney believes he's not going to get a fair trial. Obviously, under the 6th Amendment, he's entitled to a fair trial. But this case got so much publicity, it really doesn't matter where he goes in Wisconsin. All of those counties are about the same size, which is one of the things the judge is going to consider. And everyone has heard of this case. So the judge will probably deny that motion.
Yeah, we'll see how that continues as this case develops and goes on. I agree with you, Terry. I don't see a change of venue here that would survive an argument, but we'll see. And in Mississippi, a father and son are charged for chasing down and shooting at a black FedEx driver. It happened on January 24th in Brookhaven, Mississippi. 24-year-old Damontario Gibson, a black FedEx driver, says he was delivering packages when a pickup truck began following him. After that, he says at least 5 shots were fired at him. Officials say Gregory Case drove the pickup truck that followed Gibson while his son Brandon Chase fired at him. The father and son were arrested on February 1st and now face charges of aggravated assault, shooting into an occupied vehicle, and conspiracy. The case has drawn similarities to the murder of Ahmaud Arbery, during which a white father and son duo followed Arbery in their pickup truck. 25-year-old Arbery, a black man, was shot and killed. Last fall, Gregory and Travis McMichael and their neighbor, William Roddy Bryan, were convicted in his murder. Right now, jury selection is underway as all three men face federal hate crime charges in connection to Aubrey's death. This week on Prime Crime, we take a closer look at the state trial for Gregory and Travis McMichael and William Roddy Bryan. Host Jesse Weber joins us now with a look ahead to the newest episode. Jesse?
Hey there, Brian. Yeah, on our next episode, it's about the case that the whole country had followed. I'm talking about the death of Ahmaud Arbery. We start with the infamous cell phone video capturing the shooting of this 25-year-old in Satilla Shores, Georgia, and then we move into the body cam videos of officers questioning the three defendants at the crime scene. And of course, we break down their murder trial, including when the shooter, Travis McMichael, took the stand. Tune in to Law and Crime.
Thanks, Jesse. You can catch this week's episode of Prime Crime Friday night at 5:30 p.m. and 10:30 p.m. Eastern Time here on Law and Crime Network. Still ahead on Law and Crime Daily, 8 years after the crime, a jury is seated in the murder trial for an ex-Florida police captain. But first,
this is not fair. It is unacceptable. I should not have to bury a 22-year-old child.
the family of Amir Locke calls for a ban on no-knock warrants just days after he is shot and killed at the hands of the police. That's next on Law and Crime Daily.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back. In the wake of Amir Locke's death, the coming trial for Brett Hankinson, there is a renewed focus on banning no-knock warrants. The family of Amir Locke now calling for a state law that would completely ban warrants without knocking. On Thursday, Locke's family and others affected by gun violence joined famed civil rights attorney Ben Crump to rally at the Minnesota State Capitol. This comes just 1 week after 22-year-old Amir Locke was shot and killed when a no-knock warrant was executed. Body camera video shows officers raid an apartment as Locke is sleeping on the couch with a gun he legally owned. Officers fired, killing Locke. Police were looking for Locke's cousin, 17-year-old Makai Speed, who was since been arrested and charged with murder. Locke was not named on the warrant. On Thursday, family members called for a state and nationwide ban on no-knock warrants.
The blood is on the legislation.
Amen.
That's the facts. The truth needs no support. We all saw what we saw. I'm gonna tell you this now. We demand that they pass the law for no-knock warrants in the name of our son, Amir. We demand justice, and we demand that this is done properly, and not tomorrow, not later on in 2 years. We demand that it's done immediately.
I gave birth to Amir Locke in the Twin Cities, born and raised. And on 2/2/22, instead of y'all saying y'all slogan here is Minnesota nice, y'all need to change it to Minnesota lies. I am demanding that President Biden and everybody else from the ground up to the top ban no-knock warrants across the United States of America in the name of Amir Locke.
Back to break down the push to end no-knock warrants is criminal defense attorney Matthew Mangino and Terry Austin. Terry, Taylor and Locke have become rallying cries to end no-knock warrants, but what's the argument to keep them?
Well, look, there's always two sides to every argument, basically. And the rationale for keeping these no-knock warrants is they are needed to apprehend certain types of suspects in certain types of situations that are dangerous, but it should really be limited. And those situations would be situations, for instance, if there is a hostage involved. And the police are arguing to keep the no-knock warrants because they think it's going to prevent suspects from fleeing or from destroying evidence. But when you look at both sides, honestly, I think banning them altogether, except in hostage situations, might be the way to go here.
Yeah, I mean, because I'm seeing the danger not just for the people who are inside the home, but also for the officers entering as well. I can't see why others wouldn't see the same. Matthew, could this be the tipping point to end no-knock warrants both in Minnesota and even the country abroad?
Well, it may be. As Terry said, there have been reasons traditionally that we use these types of warrants, but I think they should be extremely narrowed now. There's just too much possibility of harm of innocent people. And while we hear of Amir Locke and Breonna Taylor, there are mistakes made all the time. And fortunately, they're not lethal. Someone doesn't end up dead, but people's homes are broken into by the police with no-knock warrants, and they have no idea what's going on. So I think if we narrow this down, I don't think it's a legitimate reason to say we need to preserve evidence to have a no-knock warrant.
Yeah.
Only if there's an extreme danger to police or, as Terry said, a hostage situation, should a no-knock warrant be used.
Yeah, especially in places where you are allowed to legally own a gun. It just seems like a problem waiting to happen. But we'll follow this case as it develops. And nearly 2 years after the death of Breonna Taylor, jury selection is underway for a former Kentucky police officer who was part of the no-knock warrant that led to her death. Hankerson is the only officer facing charges related to that raid, but not a single officer was charged in Taylor's death. In March 2023, Louisville police officers executed a no-knock warrant at Taylor's apartment. Her boyfriend fired at the officers, believing they were intruders. When the officers fired back, Taylor was shot and killed in the crossfire. Hankerson faces 3 counts of wanton endangerment for firing into the apartment next to Taylor's. He's pled not guilty on all 3 counts. If convicted, he could spend up to 5 years in prison. Opening statements are set to be given on February 23rd. The Law and Crime Network and I will be there in Louisville to bring you gavel-to-gavel coverage. Coming up on Law and Crime Daily, a jury is chosen, and an 8-year-old case is finally going to trial. What attorneys brought to the judge as part of their final pretrial hearing ahead of openings. Plus, attorneys make their opening statements before a jury in the trial of the accused Daytona Beach serial killer, Robert Hayes. Welcome back. And now to Florida, as a jury is selected and the trial can now get underway in the case of retired police captain Curtis Reeves for shooting and killing Chad Olson inside a movie theater 8 years ago. Reeves' lawyers maintain the former cop shot Olson in self-defense after he confronted Olson for being on his cell phone during the movie's previews and popcorn was thrown. On Friday, attorneys spent several hours hashing out final details at a hearing ahead of opening statements set to begin on Monday. Part of the discussion focused on what Olson was using his cell phone for during the movie previews. The prosecution argues Olson was contacting a babysitter about his daughter. The defense argues Olson was looking up racing sites and football scores. Defense attorneys also talked about replaying surveillance video and the effects of zooming it in, which can affect the quality of the footage. Back in 2017, a judge denied Reeves' stand your ground argument. The 79-year-old now faces a possible sentence of life in prison if convicted. Criminal defense attorney Matthew Mangino and co-host Terry Austin are back as we look ahead to opening statements in the Florida movie theater murder. Terry, with opening statements set for Monday, do you think the defense will say if Reeves will testify or not?
Well, look, if he does decide to testify, I would not signal that because you want to keep your options open. And depending on whether or not he wants to say what happened at that scene, I think that he should probably stay off the stand. He has the right under the Sixth Amendment, obviously, that guarantees him the right to tell his story, and especially if he has a self-defense argument. But we know that doesn't always work out. We saw it recently in the Kim Potter case where it didn't work out. So I'd probably not take a stand and not signal.
Yeah, I would agree with you, Terry, based on my own practice, but I'm going to bet $1 that Curtis Reeves takes a stand in this case, and it's going to be really entertaining to watch. Matthew, difference of size, even gender between aggressor and defender can be argued in self-defense, but difference of age, can that be used as well in a case like this?
Well, I think it can be, Brian. In Florida, the standard is objective reasonableness. And in this situation, it's what a reasonable person would have done in this situation. So here we have a senior citizen. Would a reasonable senior citizen have used lethal force or felt threatened to the point that he needed to use lethal force when being confronted here? As we know, he lost the stand your ground argument. He's going to have a tough time with self-defense, but it's the only option that's available.
Yeah, it's going to be an interesting defense, both with the law and the facts. We'll see how it plays out with the Law and Crime Network. In celebrity news, Netflix star Jerry Harris pleads guilty this week in a federal child pornography case. Harris, made popular by the hit show Cheer, is charged with 1 count of receipt of child sexual abuse material and 1 count of traveling with intent to engage in illicit sexual conduct. According to court documents, Harris used money and fame from being on Cheer to pay kids for sexual acts on Snapchat and FaceTime. He's been in jail since September 2020 arrest after a judge ruled he was a significant danger to the community. But Harris's lawyers now say he wants to take responsibility for his actions. Harris faces a minimum of 5 years in federal prison, but could face up to 50 years behind bars should he be given the maximum sentence on both counts. He is scheduled to be sentenced on June 28th. On top of the criminal case against Harris, there's also a civil lawsuit filed by twin brothers who say Harris sexually abused them. Also in celebrity news, the self-proclaimed Crocodile of Wall Street and her husband were arrested on Tuesday for the alleged laundering of billions of dollars worth of bitcoins. Authorities say 31-year-old Heather Morgan and her husband, 34-year-old Ilya Lichtenstein, were involved in stealing $4.6 billion in Bitcoin. Morgan is also an amateur rapper who goes by the alias Razzle Khan. The stolen Bitcoin is connected to the 2016 hack of Hong Kong-based company Bitfinex. Though the pair has not been charged with the initial hack, they could be charged for alleged conspiracy to launder cryptocurrency, which was stolen during the hack. The judge granted bail to both Morgan and Lichtenstein. The couple has yet to enter a plea. If convicted, they face up to 20 years in prison. When we come back, we dive into the so-called Daytona Beach serial killer. Hear from both sides in opening statements. That's ahead on Law and Crime Daily. Welcome back to Law and Crime Daily. Before the first witness took the stand Friday in the anticipated trial of accused serial killer Robert Hayes in Florida, prosecutors and defense attorneys had their first opportunity to make their case before the jury. Hayes is accused of killing 3 women, Laquita Gunther, Julie Green, and Iwana Payton, between 2005 and 2006. Authorities say they were sex workers in the Daytona Beach area. It wasn't until more than 10 years later, when another murder happened in West Palm Beach, that Hayes was linked to the 3 killings. That was the death of Rachel Bay. Hayes is not being tried for her death in this trial. In opening statements, prosecutor told jurors Hayes admitted to using sex workers and said his DNA links them to the victims.
The law enforcement wants to make sure, so they actually get a search warrant. They go to Mr. Hayes with the search warrant, and they do the whole 23andMe swabbing of the mouth and send that DNA off for comparison as well. And sure enough, Hayes' DNA matched the male DNA from Gunther, as they already knew. Hayes' DNA matched the DNA recovered from Iwana Payton's vagina. And Hayes' DNA matched the DNA recovered from Rachel Bay's vaginal swabs and from the top of her left hand. Ladies and gentlemen of the jury, after you hear the testimony and evidence in this case, you're going to hear from people ranging from lay witnesses like somebody on the street who didn't want to be involved with this, going to the bathroom behind a building and finding a body. You're going to hear from multiple DNA experts. You're going to hear from law enforcement from 05, law enforcement from now, officers from multiple counties, ballistics experts. You're going to get the chance to look and see the evidence yourself.
The audio from the courtroom is not very clear, so we're unable to play the defense's opening statements. He was very soft-spoken. Hayes' attorney presented an alternative possibility of how the woman died, that another possible culprit is responsible for the Daytona Beach deaths, specifically discussing a van in the area at the time that was involved in recruiting sex workers. Hayes' defense told jurors to pay attention to the small details in this case. His attorney said if Hayes' DNA matches what was found on the victims, that doesn't mean he caused their deaths. Matthew, with no eyewitnesses to these murders, what do you think will be the smoking gun in this trial?
Well, you just talked about it, Brian. It's the DNA. DNA was found on all three of these victims that matches Robert Hayes. So, you might be able to argue, yeah, he had contact with these women, but he really didn't kill them. But it really stretches, the bounds of reasonableness to suggest that he had contact with each of these three women within 72 hours of them being murdered. That isn't going to fly. I don't think that you get over that hurdle.
All right, so Matthew doesn't think it, but Terry, I'm going to ask you the question. The defense attorney's opening seems to suggest that there may be a connection that Reeves had sex with these women, but didn't murder them based on the concept of beyond a reasonable doubt. Does that sound like reasonable doubt to you, though?
Yeah, you just need that one juror to have the reasonable doubt to avoid a conviction. I happen to agree with Matt. I think there will be a conviction here, but I think it is something the defense can argue that, hey, he had sex with them, but he didn't kill them, and they were prostitutes. Maybe someone else did it.
All right, we'll see how that plays out as Law and Crime covers that case. Thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.